We are recording.
Thank you. Good morning. The Appellate Court for the State of Connecticut is out of recess and back in session on our second appeal of the morning for Thursday, March 11th, State v. Stephenson. This appeal is in front of us pursuant to a remand from the Supreme Court where the case was remanded for further proceedings consistent with the Supreme Court opinion, and we have received supplemental briefing. The judges on the panel for this appeal are Judge Alexander, Judge Prescott, and myself, Judge Alvord. We are conducting this hearing over the Teams platform, so everyone is appearing via video. All of our arguments are live streamed, so be careful with not disclosing any protected information. And if you lose the connection, please go out and click back on. We will suspend discussing the appeal while you are doing that. Okay, I would ask that the judges identify themselves, then counsel for the appellant, and followed by counsel for the appellee. I am Judge Alford.
I'm Judge Prescott.
Good morning, Judge Alexander.
You're muted.
Vishal Garg for the defendant appellant.
Good morning, Sarah Hanna on behalf of the state.
Counsel, any questions before we begin?
No, Your Honor.
No, Your Honor.
As always, each side has 20 minutes. You can, if you're the appellant, reserve a portion of your 20 minutes for rebuttal. Please let me know when you introduce yourself. Thank you.
Thank you, Your Honor. May it please the court, my name is Vishal Garg and I represent the defendant appellant Joseph Stephenson. I'd like to reserve 5 minutes for rebuttal, please. I'm going to start with the sufficiency issue that was addressed in the supplemental briefs. This court previously examined the totality of the evidence at trial and found that the evidence presented by the state was insufficient to prove that the defendant intended to tamper with physical evidence. The state's response to that argument is based largely on speculation about the meaning of several photos entered into evidence at trial. At trial, the only testimony about those photographs was that they documented the scene and that the files found on the floor were unusual. Now, despite the lack of evidence explaining those photographs, the state adopts novel explanations that it contends that those photos can be used to draw all sorts of inferences about the defendant's guilt. I think it's worth noting that the state never asked the jury to draw any of those inferences. Even more importantly, many of the state's explanations conflict with how the case was tried in the trial court. I think the most glaring of those is a file that is labeled SUM that was found on a desk. At the proceeding below, the state always claimed that the files that the defendant was alleged to have touched were the files on the floor. Now on appeal, the state says, based solely on the fact that there's a photograph of this file, that this could have been, or that this was one of the files that the defendant is alleged to have tampered with, and that that file can be used to draw the inference that the defendant was searching for his own file. We are asking this court to take a close look at the evidence in this case. In the state's statement of the facts, it doesn't distinguish between the evidence presented at trial and the inferences that it seeks for the jury to draw. And because of that, the state's statement contains both the evidence that was proven to the jury as well as the inferences that the state asks the jury to draw, many of which are unreasonable. So I'd like to start by pointing out that the state did not present sufficient evidence to connect the intruder to the case files that were found on the floor. The state presented no evidence from which the jury could reasonably infer that the intruder ever touched any of those files. In fact, the state presented...
Counsel, is it absolutely necessary that the defendant had touched those files in order to prove an intent to tamper with physical evidence?
Under the state's theory, yes. The state's theory here is that we know what the defendant's intent was because he touched those files, and that proves that he was looking for something in those files to tamper with.
Well, they're saying that that's one piece of evidence that is probative of the defendant's intent to tamper with physical evidence. Certainly not the only evidence.
I think that that's a crucial piece of the state's case. In the absence of that, I don't know that there's any other evidence that could be used to draw any sort of inference about what the defendant intended to do. I think it's important here to note that the way the state charged the defendant was with the arson and the evidence tampering as separate acts. And so certainly somebody breaking into a courthouse with several bottles of kerosene, it's reasonable to draw the inference that the defendant intended to start a fire or to use the kerosene in some way. But there needs to be some additional evidence from that to allow the jury to draw an inference that the reason the defendant broke in was to tamper with evidence.
Well, there's two possible reasons why he might want to start a fire. One is, as I understand, his trial was about to occur in the next week or so, correct?
Correct.
So he may have wanted to torch the courthouse in order to prevent the trial from going forward. He may have wanted to torch the courthouse in order to destroy any evidence of his guilt that's contained in the state's attorney's office. He may have wanted to torch the courthouse to cover up the fact that he tampered with or wanted to tamper with physical evidence, but was disrupted from doing so by the arrival of the police.
That's correct, Your Honor. I mean, any of those are possibilities. In order to draw an inference about any one of those possibilities, there needs to be some evidence to support the inference drawn.
Well, he broke into the prosecutor's office. He was carrying and left behind kerosene that clearly the jury could infer was for the purpose of creating a fire. And he had reason to believe that, and certainly the jury can infer that he understood that there would be physical evidence of his guilt in that office.
The defendant takes issue with that last point that you said about whether the defendant could infer that there was physical evidence of his guilt in that office. The only evidence presented at trial that had to do with that was a general statement from the state's attorney that sometimes files contain evidence of value and that some pro se defendants are able to look at their files. There is no evidence about what the defendant believed the state had, or any evidence that would allow the jury to draw any inferences about whether the defendant believed that the state had that evidence or any evidence.
How about common sense?
No, I don't think that the jury can rely on its common sense to draw specific inferences about what the defendant may have believed, especially in light of the lack of evidence. The evidence was that some files, not all files, have evidence in them.
But this was an attempt. And
correct.
If I'm being prosecuted by the state's attorney's office and the trial is going to happen next week, it certainly would be reasonable for me to infer that the evidence of my guilt is contained in the prosecutor's office.
I don't see why that evidence would be reasonable, or why that inference would be reasonable. In part because...
So let's take the flip side of that. So it would be unreasonable for me to infer that if I was going to be prosecuted at trial next week, that the evidence of my guilt would be in the prosecutor's office? That's unreasonable?
It would be. So let me take that example and sort of analogize it to the situation. It would be unreasonable.
Is that an unreasonable inference?
Not for you, not necessarily for you to draw. It would be unreasonable for me to conclude that you had drawn that inference without any reason, without some sort of evidence that allowed me to suspect that you had drawn that specific inference.
But we can never look into a defendant's mind and see exactly what they're believing at any particular point in time. We use common sense to do that. We use, our everyday life experiences as to whether or not we want to infer, whether the jury could infer that that at the least the defendant thought there would be evidence in there.
Well,
Go ahead.
We do use common sense, but that common sense needs to be in light of the circumstantial evidence that's presented at trial. I mean, we can't just use common sense to draw any inference at all that we want to about the defendant's guilt.
He didn't break into the public defender's office.
No, he didn't.
He didn't break into the foyer of the courthouse.
No.
He broke into the very office of the prosecutor who was prosecuting him.
That's correct. So, there are a couple of things that I want to point out about that. So first, we don't actually know that he had any way of knowing which office belonged to which prosecutor. The state didn't present any evidence about that. I mean, it's unclear from any of the photographs whether or not there are labels that say which prosecutor works in which office.
Didn't they present evidence that he had been casing the courthouse for some time, including near those windows?
The evidence was that he was casing the courthouse while it was closed. This occurred all on a Saturday evening. And so there was no evidence that anyone was inside the building at the time he was casing it. The evidence was essentially that a car that the defendant had access to had parked in, I believe it was a parking lot either across the street or next door at a bank. But there was no evidence about whether or not casing it would have allowed him to determine which office belonged to which prosecutor. And so kind of getting back to the idea of being able to determine intent, we do that by looking at the evidence at trial and combining that with our common sense. Oftentimes we can infer someone's intent by when they do something that is very close to a completed crime. For example, if someone fires a gun that misses, we can infer that they had attempted to shoot someone. And that allows us to arrive at an inference that the defendant had the specific intent to murder. Here, it's entirely speculative what the defendant intended to do. The state's theory is that he went into the state's attorney's office and rummaged through some files and pulled them out of a shelf. There's not actually any evidence that supports that. We don't know where the files were before the break-in. The state chose not to present any evidence about the state of the state's attorney's office before the break-in. This is certainly evidence that was in the state's capacity to present. The police, for whatever reason, chose not to either fingerprint or DNA swab any of those files, and so we don't even know whether or not the perpetrator touched them. The state asks the jury, or asks this court to conclude that the jury could reasonably infer that the defendant went through those files based on the bare fact that those files were found on the floor, despite the fact that we don't know where they were before that.
But isn't that the point of a criminal attempt, that the state doesn't need to prove he touched it or not, that his intent was to go in and destroy evidence based on all of the circumstances?
Yes, but the main circumstance that the state relies on here is those files that were found on the floor.
Because there's a lot of files in a prosecutor's office. He wasn't going to, If he completed his act and lit the office on fire, wouldn't he have destroyed evidence?
No, but that is, I think, because of a separate issue, which is the question of whether or not anything in the state's attorney's file actually constituted evidence. So part of what the state needed to prove in order to support the tampering charge was that the defendant intended to destroy evidence with purpose to impair its verity or availability at trial. Here, the state hasn't presented any evidence that the defendant had any reason to suspect that any of the materials in the state's attorney's office would have been entered into evidence at his trial. I do want to quickly—
You have a minute left, Attorney Garg.
Thank you, Your Honor. Before my time is up, I do want to get to this evidentiary issue because I think it's important. So here, the state has conceded that the evidence was not was improperly excluded. This is the evidence about the defendant intending to plead guilty. The state's case is based largely on its theory that the defendant was doing this in order to avoid trial. I think at the close of the state's brief, it specifically references the defendant attempting to avoid having to take responsibility for these cases. That was the defendant's goal in doing all of this. Had the jury been told that the defendant had already decided to take responsibility for this, it paints the case in an entirely different light. It suggests that the defendant's purpose was not to prevent a trial from happening, but to do something else, either to take revenge, maybe to prevent a plea hearing from happening, which is a completely sort of different story that would be in front of the jury. I think it's a hard sell for the state to say that the evidence was, or that the defendant was not harmed by the admission of the evidence, especially in light of the fact that a 3-judge panel of this court previously found that the evidence on intent was insufficient as a matter of law to sustain the conviction. And I believe that's my time.
It is. You do have your 5 minutes.
Thank you, Your Honor.
Attorney Hannah.
Good morning, Your Honors. May it please the court. On behalf of the state Senior Assistant State's Attorney, Sarah Hannah from the Appellate Bureau of the Office of the Chief State's Attorney. As there are multiple issues in this case, I will address those that the defendant has addressed. And then, of course, if this court has any questions beyond those issues, I will certainly attempt to answer those as well. With regard to the sufficiency claim, the defendant attempts to pick apart each individual piece of evidence. This is not correlative with the proper sufficiency standard of review. We must look at the entirety of the evidence together. In addition, the defendant ignores several key pieces of evidence, namely the overall plan in and of itself shows that the defendant was a desperate man. His attempts following the crimes to fake an alibi and then also present that alibi to court show that he was a desperate man. The defendant also ignores the fact that he entered the individual prosecutor's office and attempts to mark that up to pure coincidence. The jury could have found that as a coincidence, but it was not unreasonable to find that it was not coincidence. The defendant here cased the side of the building. He went to that side 3 different times. The jury can infer that he was looking for a specific office. And then he entered the office of the prosecutor on his case. This is not coincidence. The defendant also ignores the defendant's phone call following the break-in. He called the court to find out if he had succeeded in disrupting. He asked if he had to report to court. That is demonstrative of his intent. He wanted to disrupt proceedings. Here, the entirety of the defendant's actions support the inference that he intended to tamper with evidence. First, we must remember we have to start with the idea that identity is not an issue. Identity is overwhelming the evidence as to identity. So this intruder was the defendant. Every action that was taken was done by this defendant. So we have this defendant who makes this plan to enter a courthouse with 6 bottles of kerosene. This is not a normal everyday action. This is desperation. The jury can infer that that desperation stems from his felony cases, which had been pending for 2 years. Those cases were not going to be delayed any longer, and he was desperate to do something about that. His desperation influenced his plan to enter the courthouse with 6 bottles of kerosene. Then he not only had that plan, but he specifically formulated that plan and was tactical in his plan. He surveilled the courthouse, went to the side of the building where the prosecutor's office was, and then he entered the particular prosecutor's office. From there, he didn't immediately start a fire. If his intention was only to start a fire or for revenge, the inference would be he would have destroyed the prosecutor's office. There was nothing awry in the individual prosecutor's office. There was nothing awry in the rest of the state's attorney's office. He put down the kerosene. There was no liquid kerosene around. He put that down. And the inference is he went to the files. Going to the files indicates his intent to tamper with those files, because those files are what his prosecution is based on. The defendant contends that it's unreasonable for the jury to infer that the defendant believed that the state's attorney's office contained materials relevant to his prosecution. That's the only reasonable inference. The defendant's cases have been pending for 2 years. It's unreasonable to infer the defendant had no idea what was going on against him in the course of his cases. The defendant pulls files. They're alphabetically near his name. Is that extremely significant? No, but it adds to this the stacking of facts that create this picture of what the defendant's intent was in entering that courthouse. Again, this is an attempt crime. The state did not have to prove that the files he touched, that he even touched files, or that the file he touched contained what the specific requirements of the statute, but only that the defendant believed that they contained those things. And the state submits that the evidence shows that he did believe that. There's also the common sense inference of the defendant is in a courthouse in the middle of the night, handling files. There's no, what else is he doing there? If a defendant breaks into a bank in the middle of the night, it's reasonable to infer that he's trying to get money. Yes, certainly he could have been going there to sleep. He could have been going there because he forgot he was employed there and forgot his cell phone. But it's not unreasonable to infer that he was going to take money. Same with the entry into a home. You infer that he's going to take or destroy or do something to the items in the home, not that he's there to sleep. Here, he entered a state's attorney's office. The state's attorney's office has files. It's reasonable to infer that by entering that at the time he did, with the desperation he had, he was intending to tamper with those files. With respect to the defendant spoke about the evidentiary claim. I think that the state's brief is complete on that issue. I would like to point out the fact that this case below was about identity. The idea of motive, intent, those were all sub-issues of identity. The state's closing argument went to identity. So anything it talked about or didn't talk about was related to the idea of identity. The state did mention, that he had the intent to tamper, but it's not based on this idea that this particular motive. Certainly, the motive of a trial beginning is important in terms of the building blocks of the state's case, but that only gets us in the door in terms of the defendant's identity. What he's doing is he has cases, whether he's going to plead guilty or going to trial is irrelevant. Clearly, he has cases that are pending for a long time, and he's breaking into the courthouse. That's where that piece fits in into this framing, this desperation of the defendant. So this single piece of evidence certainly was not, the exclusion was not constitutional error and certainly was not harmful. For the remainder of the issues, the state would rely on its brief unless the court has further questions or questions.
I have none. Okay, Attorney Garg, you have 5
Your
minutes.
Honor.
Thank you.
Thank you, Your Honor. There are a couple of things that I want to start with. The state focuses on how it's reasonable to draw inferences based upon the type of place that someone breaks into. If they break into a bank, it's reasonable to assume that they're there to steal money. If they break into a home, it's reasonable to assume that they're there to steal something. But what the state leaves out is that the defendant broke in with 6 bottles of kerosene. If a defendant breaks into someone's home with 6 bottles of kerosene, is the reasonable inference to draw that the defendant was there to steal something, or is it that the defendant was there to set a fire? If the defendant breaks into a bank with 6 bottles of kerosene.
Or both.
Or both. But the point is that when you have something where the natural interpretation is that the intent is to start a fire, there needs to be some further evidence to establish this alternative intent. And the state has not presented that here.
Attorney Garg, I may have missed this, but what's your explanation for him setting down those 6 bottles of kerosene?
He was interrupted in the middle of the event. He put down the kerosene and ran away.
How do we know? So your position is he was ready to go with that kerosene and then put it down, as opposed to entering and putting it down? I'm confused. How do you get to the timing there?
He entered into the building. I believe the evidence is that within 90 seconds or so, the police were there and disrupted him.
That's a long period of time. He's just he's not in a big space.
Right. And so we don't know what he was doing during those 90 seconds.
But we do know that the bottles of kerosene were not activated. They were put down.
Yes, we know that he was interrupted before he was able to start the fire.
You're going to light the courthouse on fire. Aren't you going to activate those kerosene instantly? If that's your goal, aren't you going to light those up and get the hell back out of the window you came in through?
Probably, yes. But
so
we
what
don't
happened
know.
in those 90 seconds of dithering around?
And why wouldn't he have taken the kerosene with him rather than putting it down if he still had them on him when the police arrived? Isn't it more logical to infer that he had already put them down to search for the evidence related to his case and then could not retrieve them in time when the police arrived?
I don't think so. I mean, if he's going to run, he doesn't really want to be carrying a duffel bag full of kerosene.
Well, he got through a window with it.
He did, but he wasn't running at the time.
No, he was climbing.
Yes, but he wasn't in a hurry. But I do think it is kind of important to point out the state acknowledges, both during its argument and its brief, that it needs to prove that the defendant believed that the files contained evidence. The state's argument and the evidence only gets to the idea that the defendant believed that the files contained things that were important to prosecuting the case, as opposed to actual things that were going to be used as the evidence against him.
1 minute.
Thank you.
Yep.
And so I do want to just conclude by kind of hammering home this point about the state's theory is premised on the idea that the defendant has a trial or was going to avoid a trial. When you look at the state's argument, and I'm talking about its closing argument during the trial, that was the heart of its theory. On pages 17 and 18 of my initial brief, not the supplemental brief, there are a series of quotes about the state relying on the defendant's trial to establish his guilt, and specifically to establish his intent to tamper with evidence. The state's theory was that he wanted to tamper with the evidence to either stop his trial from beginning or at least put it off. And so the fact that he had already decided that he wasn't going to have a trial and wasn't going to plead guilty, had the jury heard that, it almost certainly would have changed the jury's analysis of this case. the evidence here is not so overwhelming that knowing that, or that this wouldn't have changed the outcome. The state certainly hasn't shown that this wouldn't have changed the outcome. Given the weakness on the state's theory of intent, evidence that the defendant had intended to plead guilty would have more than likely changed the outcome of this case. And if there are no further questions, I will rest on the briefs and the arguments that I've made to this point. Thank you.
Thank you, Attorney Garg and Attorney Hanna. We will conclude the hearing and leave the courtroom. Thank you.
Thank you, Your Honors.
Thank you, Your Honors.